Hello everybody, my name is SHIVAM and I am advocate practicing in law. Let's discuss the law provision related to triple talaq for protect the right of married Muslim women and to prohibit divorce by pronouncing triple talaq by their husband. Legislature passed the Act, the Muslim Women Protection of Right on Marriage Act 2019, and that comes into the force of 19 September 2018. This is a very small act along with 3 chapter and 8 section, but that is a very powerful, that is a very beneficial for the protection of right of Muslim women. If we discuss about this act makes it clear that talaq-e-biddat, practice of talaq-e-biddat or similar form of talaq will be void and illegal, and violation of this act there is a punishable offence and there is a up to 3 years of imprisonment along with the fine provision is defined in this act. If we discuss about the nature of these offences, this offence will be cognizable in nature, means police officer can arrest without the warrant to the Muslim husband. But we remember this offence is cognizable in nature only when the information is received in the police station by the affected married Muslim women or any person related to her blood or marriage. So again, if we discuss the next concept about this act, it will compoundable. So my answer is yes, victim female with the permission of concerning court can compound that matter. If we discuss about how we can get the bail from this act, so the answer is after hearing the victim female, the concerning court can give the grant the bail to a Muslim husband. So this is the whole process about this act. This is a very summary manner I discuss about this act. If we discuss section 5 also, there is a allowance related provision. If we discuss section 6, there is a custody of minor child related issues. So whole this is a very effective act for the protection of women's right, and that's a very wonderful act for the protection of the triple talaq related issues. So again the question is there, because in the issue of triple talaq there is a up to 3 year imprisonment. So the question is there, is it fair to make a criminalization of the triple talaq? So for support of my answer I will share some of the example. Let's see the section 498 of IPC, where the husband or relative of husband subjecting her to cruelty, that is a punishable offence. There is a up to 3 year of imprisonment and the fine provision is defined in our the IPC. If we discuss into the Domestic Violence Act, then basically Domestic Violence Act is a civil in nature, but if we look the section 31st of the Domestic Violence Act, we find out that after violation of the protection order by the husband, there is a penalty up to 20,000 rupees or there is imprisonment of 1 year or both. That's the define. So how we can say that to make a triple talaq is a criminalization, to make a triple talaq is a criminalization, so that I think that is a no any question need not to discuss. And for support of my answer, we need to see the section 377 where unnatural offences, and that is a not fully lapsed. If the consent of both party, then it is a not punishable offence. Means punishable offence is 377 when there is a one side, means unilateral, then it is a punishable offence, and it is a not punishable when it is a bilateral, means both sides. Same as well triple talaq, if it is done in a unilateral method, then it is a punishable offence. If it is done in a bilateral method, then it is not punishable offences. Again in our article 44 of the Constitution, where the uniform civil code for all citizens is there, hope legislature make it comply about the article 44. Again the some question that comes through to mail, that's why the legislature passed this triple talaq related bill. So basically we see in our society back there was a sati related practice, but legislature passed the act for Sati Provision Act. In our society back there was a untouchability related issues, so legislature passed the effective act. In our constitution also the untouchability related issues, legislature passed the effective measurement. In same as well there is a triple talaq related issues, so legislature passed the act, the name of Muslim Women Protection of Right on Marriage Act 2019. So basically the people have some question the triple talaq is only against the talaq-e-biddat or similar nature type of talaq, like as a practice. Triple talaq 3 times says the talaq, that triple talaq is against of only that talaq-e-biddat format. If we discuss about the talaq-e-sunnah, that's a traditional process. Still, that is a progress on. There is a no any, that is a not punishable offense. So people are confusion. So let's clear about that concept also. If we discuss about the dissolution of marriage in the Muslim, then we find out there is a 4 ways where the dissolution of marriage can be done into the Muslim, by the husband side, by the women side, by the mutual consent of both parties, by the judicial process. These are 4 ways. If we discuss that traditional concept, there is a talaq-e-sunnat and talaq-e-hasan. Talaq-e-sunnat in literally that has been categorized into talaq-e-hasan and talaq-e-hasan. But we remember why in this process there is a chance of the arbitrariness, there is a chance of settlement, there is a chance of conciliation, there is a chance of discussion. Means there is a good chance that the marriage can be restored between the husband and wife. So again, but the later on the advancement of society, the new format comes like in the form of talaq-e-biddat, and there is a pronouncing of triple talaq, instant triple talaq, that comes into the practice. So the question, so the triple talaq was against the talaq-e-biddat. Again I am repeating, triple talaq is against the talaq-e-biddat. Talaq-e-biddat or similar form of talaq, triple talaq is against of that. So basically if we discuss, that comes into the Supreme Court challenging only practice of talaq-e-biddat. Again I am repeating, why I am repeating more and more time, reason is behind that. The Muslim community basically they are making rumor, they are spreading new rumor that government is interfering about our tradition, about the religious feeling like as that, and like as some political leaders, they are always saying that government is against our religious feeling and other things. That's the constitution right of article 25, that the government is interfering in our religious. So basically I would like to again make it clear that triple talaq is against the talaq-e-biddat format also. That is a later on, that is not the traditional practice of the Muslim family. So basically that was the challenge of only practice of talaq-e-biddat. I repeat more than the 4 times. Why? Because it must be aware, people must know that what is the real meaning of the triple talaq bill. So if we discuss in the landmark judgment of SHIVAM versus Union of India 2017, there were the 3 issues where has been found that instant triple talaq, that was the challenges, nikah halala was challenges, and polygamy was the challenges. And there was a petitioner was the Sarah Banu, and the respondent of Union of India, Rizwan Ahmad was the respondent. Ministry of Minority Affairs, Ministry of Law and Justice, Ministry of Women and Children, there was a respondent party was there. So basically the Supreme Court, the question in front of Supreme Court was there: essential religious practice or the violation of fundamental, which is better, which need to solve in this landmark judgment of Saira Banu versus Union of India 2017. So Supreme Court 5 judges bench with the order of 3-2, they decided that matter should be go in the Parliament, and Parliament need to make a bill related to triple talaq related issue for solve of the issue. So